We have been instructed by our client, Mahadi Energy Limited, and Mahadi Energy Limited owns one of the top 5 biggest inland container depots in this country. And the background is that Mahadi had taken some loan facility from what was then called First Community Bank, amounting to over 630 million Kenya shillings. Over due time, rather in the course of time, Mahadi claims to have already paid off that loan, given that it was a loan that was advanced in terms and in line with the Sharia laws that govern Islamic banking and finance. Now, these laws are very particular to the way the issue of interest and other charges are handled, given that the principles underlying Islamic banking and finance is that money is not and should not have an intrinsic value, but as a means of exchanging goods and services. Now, Mahadi, or rather First Community Bank as it then was, which was then later acquired by Premier Bank, went and obtained auctioneers and auctioned the properties belonging to Mahadi. And we even have reports that some of these properties which were auctioned were not charged over the initial loan. Now, after that, Mahadi then went and moved court, filed an application dated the 18th of October 2024 in Mombasa, and Honorable Justice Olga Sewe issued conservatory orders, given that it was in the form of a petition, stopping the auctioneers and everyone who had claimed to have bought that property and all those properties that had initially allegedly been charged from entering and dealing with those properties. Later on, those orders were then reaffirmed on the 25th of October 2025 by Honorable Justice Mutai. And unfortunately, as we have been seeing as a crop of practice, evicting Mahadi Energy Limited from the properties they allegedly bought from that auction. We then moved to court with an application which we filed on Friday the 24th, and in it we are arguing that the orders which they obtained and were given by Honorable Justice Kulo of the Environment and Land Court here in Nairobi were improper and illegal on the basis that they were obtained when, or rather, having had an issue of material non-disclosure. Because the non-disclosure in this point points out to they did not disclose the fact that there was existing orders from Mombasa by the judgment, by the ruling of Honorable Justice Gregory Mutai, stopping and barring the interference of those properties. But here again, we can see they moved the court in the ELC and obtained what we can now call arbitrary orders, which are now evicting our clients from what has been termed as an illegal acquisition of their properties. And we say illegal not so loosely, but as a matter of fact, given that even at the time of obtaining these auctioneering orders, the debt that was allegedly owed to Premier Bank was not established and has no equal footing to warrant the orders that they received. Therefore, our application has been given directions to be heard today on an urgent basis, and we are awaiting the directions of the court and the file has been actioned to Honorable Justice Mohammed Kulo.